this time, Ms. Vito, you may proceed.
Thank you, Chairman Gardner, members of the Commission. Christine Vito, Senior Analyst with Human Resources, for the record. I will be facilitating the interviews today for the Tahoe Township Justice of the Peace. As I mentioned prior to reading of the agenda item, we will be starting with Mr. Johnson this morning, as our first candidate has not arrived yet. Just a few items to mention. The applications and letters of reference submitted by the candidates are in your board packet starting on page 93. Interview questions are being handed out this morning and being provided as supplemental. As Chairman Gardner mentioned, out of courtesy, we have asked all three candidates to not sit in the chambers while the others are being interviewed. So we will require a brief pause between each interview to shuffle the candidates in and out of the room. I will be reading the prepared questions today. There are 10 prepared questions, but this board may ask follow-up or clarifying questions throughout the process. Do you have any questions for me before we get started?
I have a few of my own questions that are not follow-ups. So can I ask those when we're done with these?
Yes, I would recommend getting through the scripted questions first.
I do have questions myself. If they don't come up in the process, then I'll be prepared to make those questions as we go through this. There will be a public comment period after each of the candidates, so that we can hear from. Don't you want to do it at each? No.
It's up to you, sir. Your discretion.
I don't know. How would you prefer to hear public comment, commissioners? I'm gonna let the rest of the board actually just make. Would you prefer to hear public comment on after each candidate, or at the end of hearing all three? Does it make any difference?
Personally, I would rather it after all the candidates have had a chance to speak.
After, okay. So we'll do it that way. Okay. So we withhold public comment until after we've heard from all three candidates. Okay. We'll do that. Very good. So.
Mr. Chairman, members of the Commission, this is Christine Vito, Human Resources, for the record. Our first candidate today is Mr. Michael Johnson. Welcome. I will be asking the questions on behalf of the board, Mr. Johnson. If you would please provide your responses directly to the board, and they may be asking you follow-up questions after your responses.
Sure.
Are we ready to get started?
You bet.
Okay. Your first question is, can you please tell us why you are interested in the Justice of the Peace judgeship?
Sure. So I started as a practicing attorney in 1997, and I don't know that I had judicial ambitions for the first few years. I was working as a junior attorney and associate attorney in a law firm run by Judge Glasson and others at the time. So Judge Glasson, before he was judge, was my boss there. Once he became judge, he asked if I had an interest in being put on the pro tem list and filling in for him on occasion. And, you know, I didn't do it right away. I wasn't sure I was prepared for it right away. I don't know that I had the highest level of interest in it at that time. At that time, you know, I was a lot younger then. I was interested in advocating for a client, taking sides and, you know, representing a client in an adversarial proceeding. Then I finally gave it a try as a pro tem, sat in for Judge Glasson in 2006, is the best I can figure based on looking at my old records. And I really surprised myself that I really enjoyed the process. It felt really meaningful. Instead of advocating for a client at that time, one side or the other, I was advocating, if that's the right term, for the right result, for a correct legal ruling, for a correct factual determination, and doing the right thing and doing the fair thing for the parties. And I found that I really enjoyed it, and it was meaningful work. And I think shortly after the first time I filled in for Judge Glasson, I told him or anybody else who would listen that, yeah, Judge, you know, when you retire, let me know, or when you're getting ready to retire, let me know, because I think I would like to have this job someday. So here I am 17 years later.
Mr. Johnson, what do you believe would be your most important contribution to the court?
Well, you have to hit on so many categories here. I mean, I think, first of all, I would be a calm influence on the court and the litigants and the attorneys that appear in front of it, because I don't get worked up about things myself too much. I think I'd be good on the administrative end of the court. At least I take an interest in what goes on in the administrative end of the court. I think with my experience as an attorney in that court, and as a pro tem judge to a lesser degree, I think I'm in a good position to make correct legal decisions, or at least I've seen the issues before and know how to deal with them. So, yeah, I think that's the way I'd answer that.
Can I ask a follow-up to that one? Welcome this morning.
Thanks.
What's your understanding of the organization of court clerks in the county?
Probably a poor understanding of it. I know that Bobby Williams is the chief clerk, and the other clerks, including the clerk of the Justice Court, report to Bobby, Ms. Williams. I know the court, I think there was a Nevada Supreme Court case, I don't know, 10 or 15 years ago, where there's sort of a question as to what supervision the Justice Court judge, or maybe that was a district court judge, I don't remember specifically, but there is a question as to what authority the judge has over the clerks. And I think when it comes to, courtroom duties, I think ultimately those are decisions that are going to have to be made by the presiding judge. But obviously, cooperation and deference to the expertise of the clerk's office is important as well.
Mr. Johnson, can you please tell us what you know about the Tahoe Township?
Sure. Let's see, geographically speaking, I don't know that I can give you a meets and bounds description, but basically the folks up at the lake. So folks like me that I've lived on Kingsbury, off of Kingsbury for 26 years, and then it extends, to the state line and then up to Glenbrook. I think I read somewhere that Tahoe Township, this is a post office statistic, is one of the most transient zip codes in the country, excluding military bases and college campuses where you'd expect that sort of thing. I don't know that that's true anymore. It seems we have a lot of longtime folks there, but that's sort of a lot of new people come into town a lot. Everybody likes to tout how long they've lived at Lake Tahoe. It's a great place. It's, I came here to live in Tahoe Township. That's why I'm here. It's the most beautiful place on earth. And good people, well-run governmental entities. I'll leave it at that.
Mr. Johnson, how do you ensure that all parties involved in a case are treated fairly and with respect?
Well, I guess you start with looking at the rule from the Nevada Code of Judicial Discipline on whether you should recuse yourself. That's an easy one, right? If you shouldn't be hearing the case in the first place, if you do hear it, you're not following the rules, and you're not providing fair result to both parties. I think you can look at it from a musician auditions at times. These symphony orchestras, they have somebody and they do blind auditions, right? They have them come behind a curtain and don't let the person's looks or history influence their decision. That's not possible to do that in this context, of course, but you can kind of apply those principles to your thinking and put yourself in the position of both litigants and decide that, I'm not going to let their personal beliefs or my personal beliefs have a disproportionate impact on a ruling or a decision.
A loosely related follow-up. And this is not just in relation to the parties before you, but in everything you do if you are appointed. What practices do you have in your life, or would you have in your life, to guard against judicial arrogance?
Well, I have seen it in the past, right? We call it black robe syndrome, that maybe makes people behave differently than they did when prior to taking the bench. So I think using that as a cautionary tale, I'm not, above that sort of thing, if I would imagine, unless I'm diligent and vigilant about not letting that affect me. I don't know. I guess it's just the attitude that you have going into this. This is a job. You're here to do it correctly. It doesn't put you above anybody. Just puts you in a position where you're making important decisions, and you should be, if anything, the position should make you more humble rather than more arrogant.
Mr. Johnson, please give us an example of when you entered a job or situation and had to make decisions immediately without time to get your bearings.
So I'm going to say that as coming out of law school, they don't really teach you the practice of law in law school. They teach you a lot of abstract concepts, and I tried to get some clinical, practical experience, but mostly it was just reading textbooks. And so when I first started to work as a, wet behind the ears attorney, I was expected to, I was expected to be a real lawyer. I didn't feel like I was prepared to be one at that point. And I think the idea is you got to know your limitations. You got to tell people, whether it be your client or your supervisor at the time, of your limitations, and do the best you can with it. I was put in this even before I became a lawyer. I had the opportunity to do a contract as a prosecutor. This is even before I finished law school. They had I think Nevada recently adopted a similar rule that allows law students to actually practice law, appear in court, handle trials when they haven't even finished law school yet, let alone pass the bar. And it was getting thrown in the deep end. And all you can do is make sure you're prepared as you can be under the circumstances. And I think it worked out okay.
So I'd like to this is a perfect opportunity for me to make this statement, I believe, okay, in that right now you're thinking on your feet, okay? And I think it's important for the audience to understand that this is the first time that Mr. Johnson has heard these questions, okay? These questions have been prepared by our Human Resources Department to assist the interview process. This is the first time that commissioners are seeing these questions, and the candidates have not been provided with these questions in advance of this. So they're not really prepared. They don't know what's coming before them as we speak right now. And that is basically a primary reason why we're not having the other two candidates sit here and listen to these questions so they can formulate answers while Mr. Johnson is answering them. So I wanted to I meant to say that in advance, but this gave me the perfect opportunity to introduce that, because we asked him, on your feet, how are you making decisions? So anyways, okay, thank you. You proceed, please. Thank you.
Mr. Johnson, give us an example of a difficult problem you worked on and walk us through your decision-making process.
First of all, I want to thank Mr. Chairman for making that comment. I would like to think I could be a lot more eloquent answering these questions if I had the ability to prepare for them. A difficult problem that I've had to work through it. When I get into a new area of law, I had to deal with some very arcane statutory issues a few months ago that I had no experience in at all. And I get out, maybe a kind of visual person, so I will, at least sometimes when you read statutes, it's like, reading TV installation instructions or stereo installation instructions or something. You need to diagram things. So what I did was put a big piece of paper on my wall and diagrammed it. And there's a statute with 100 different parts to it, go through it one by one, and it makes more sense to me when I do it that way. So it's kind of like a scorecard when you're interpreting or writing a brief that involves complex legal issues. I kind of go to that method. Whether it's advised or not, it seems to work for me.
Mr. Johnson, tell us a time when you were involved in settling a disagreement and successfully maintained relationships.
So, I mean, I've acted as mediator on quite a few cases. So a mediator is a person without any real power. They are there to take the two litigants, the two adverse parties in a lawsuit, and make suggestions, maybe cajole a little bit, be a conduit to try and get them to come to an agreement. So I've been mediator more times than I can count. But maybe a better way of answering that question would be when I'm trying to get a resolution. Most lawsuits settle, right? I don't know what the statistics are, but probably 95% of all lawsuits settle short of going to trial. And that's for a lot of reasons, usually practical reasons and monetary reasons. And so when you're in a lawsuit, there's a good chance it's going to settle, just statistically speaking. And especially when I do a case involving a neighborhood dispute. Do a lot of, in fact, my writing sample that I provided, not super compelling reading, but it's sort of illustrative of the kind of practice I do a lot of the time. It's a neighborhood dispute. It's folks that had an issue over easements or boundary lines or whatever it is. Sometimes it gets nasty, sometimes it gets contentious. But this person, we can beat them in court, maybe, but you're gonna have to live next to this person when the case is over with. So we don't take a scorched earth approach toward litigating matters unless it's, absolutely necessary.
Mr. Johnson, please provide an example of when you chose to be true to your own values rather than do what was told or expected.
I think there are times when clients ask me to do things that, well, certainly not illegal and maybe not even unethical, don't sit well with me, aren't the kind of thing I can get behind, maybe not the kind of thing I could be proud of. So there are occasions, even with good clients of mine, that I tell them, before I get to the point that I tell them we're going to have to break up, try to convince them that I'm correct. I'd like to think so anyway. Convince them why taking the high road is, in the long run, going to be a preferable route. And then the occasional time when we can't come to an agreement on that, just decide they may be better off with another attorney that can pursue the course of conduct that they have in mind.
Mr. Johnson, can you describe when or where you learned the most about your strengths and weaknesses?
Well, I guess it's when, I'm thrown a curveball, when I'm handling a legal matter that I don't have experience with. There's some certain types of matters, subject matter, jurisdictional matters that I do all the time, and I've done it enough times to know sort of what the likely outcome is and how I'm about to handle it. But when something new comes up, I'm sort of forced to decide, am I the best suited person to handle this particular matter? And I think at those times, you got to decide, sometimes the answer to that question is no. And you either refer the matter to another attorney or ask for some help, or tell the client about your limitations on it.
Mr. Johnson, tell us a time when, let me repeat that. Tell us a time your role in a group wasn't effective, so you changed the way you work with them.
Role in a group? Okay. I spend most of my time working alone at my office, I suppose, so I don't know that I have a lot of group involvement, or at least not group involvement that's gone awry. I would say this, maybe in the capacity as mediator. So again, back to mediations, where you put one set of litigants in one room, another set of litigants in another room with their respective attorneys, and the mediator shuttles back and forth and tries to convince everybody that it's best to work things out rather than go to court over the issue we're discussing. And, so you're dealing with two different groups, and, what motivates one group to, in my view, see reason or resolve their dispute may not work with another. And so maybe my traditional approach to having people see reason, I have a whole kind of set of ideas that I have in a mediation as to telling people, having people recognize the realities and the expense associated with litigation. That may not motivate somebody that, for example, is not concerned with the expense of litigation. So we have to come up with new ideas to let them know that they should be exploring all their options, and that may involve settling a case.
I have a follow-up question to that. So you have served as Judge Pro Tem since 2006. Is that what I
In the
show
Tahoe.
here? Okay. So have you served in those cases? Have you served as a mediator between two parties in cases in court and work with those two groups as a Judge Pro Tem in that same capacity?
Right. So there's a real have to be real careful. If you're the judge on the case, just making the ultimate decision on the case, it's usually considered best not to participate in the mediation. The idea behind a mediation is the parties can speak freely with you, right, without fear of affecting the result. And so, no, I think normally, there are times when the parties will stipulate and agree, yes, we want you to resolve this. I can't think of ever having done that in the Tahoe Township Justice Court. Most of my mediation experience is when I'm hired as a private mediator or I'm designated by the El Dorado County Superior Court as a dispute resolution conference mediator. And I'm just there as a mediator, not as a decision maker.
Mr. Rice, you had a follow-up question?
I do need to make a disclosure. I worked as the deputy constable in the Tahoe Township Court for about 15 years, and I have served in many cases where Mr. Johnson was the attorney, as well as I know one of the other candidates quite well. And I want to assure you that my relationship with them will have no determination on my choice of candidates.
I believe we're done with the 10 questions. No, we're not. I just meant to say that we're done. Ms. Vito has concluded her 10. So I want to give now each commissioner an opportunity to address questions that they might have, right? That's what I was doing. And you can go first if you wish.
I just wanted to say, first of all, I appreciate you reaching out to me, trying to meet me in person. It shows the desire that you have and the work ethic that you want for this job. Maybe we can meet again if you want to after this meeting, but I didn't want to meet before it because we were having these open meetings. Number two, I'm very impressed with all of the letters in support of you. I believe the entire supplemental packages all support of your positions. So whoever you have spoken with, they have done a great job, and it also shows your desire for this position.
Thank you.
No follow-up questions. Okay. Commissioner Hales, did you have additional questions you wish to ask?
I have two. Could you walk us through very briefly how you would hold an arraignment?
Sure. So the arraignment is the first appearance of a criminal defendant. You advise them of their rights, just like they say on TV, they have the right to remain silent if you choose to say something that may be used against you in future proceedings. You want to talk to them about whether, well, first of all, if they have an attorney there. This is usually handled through the attorney if they have an attorney. And then ultimately, you're there to, you might be discussing bail issues, particularly if they're in custody. You want to resolve bail issues at that time. And then ultimately, you may ask them to enter a plea, guilty, not guilty, no contest to the charges presented against them.
Thank you. And my last question, would you describe a time when you personally have seen a justice of the peace, could be you when you were pro tem or another justice of the peace, when you've seen a justice of the peace have a meaningful impact on the life of a person before them?
You know, it's hard to say, right? Because you see what happens in court. You don't necessarily see the follow-up and what happens later. But there sure are times when a criminal defendant, for example, I've seen Judge Glasson speak to a criminal defendant in a non-demeaning way, but provides life advice that, gosh, I sure hope they're listening. I sure hope they're using that to their long-term advantage. Can I, do I have quantitative data where somebody was, educated about something and then, turn their life around based on that? I think it's inevitable. I think it has to happen. I can't point you to a specific example. I can't name somebody off the top of my head where that happens, but that's what this process is set up in part to do, is to give people the opportunity to, make changes to whatever disposition they had that got them into that trouble in the first place.
Okay, additional? No? Commissioner Nosad, any questions of this candidate?
Just real quick, Mr. Gardner. The last question asked. Mr. Johnson. Oh, Johnson, I'm very sorry. Wrong page. All right. Same question. Tell us about the time your role in a group wasn't effective. That's for part one. Part two says, so you changed the way you worked with them. Do you have a specific case that you care to share with us?
So you're bringing up the question that was asked to me earlier by Ms. Vito. Is that right? I just had a little trouble hearing
Number
you.
10.
Okay. I touched on it a little bit in my answer. It was in the context of a mediation as mediator when I was there to, it's two sets of groups actually, right? You've got the plaintiff's group and the defendant group over here. And by the way, this doesn't always, settling these cases doesn't always mean somebody writing somebody a check. There are non-monetary ways of settling cases. You'd be surprised, sometimes an apology from one side goes a long way toward resolving an issue. And so, for me to go in as mediator and says, you ought to accept this offer, or I think this is a good deal for you, would be arrogant on my part. I think you need to talk to the folks that you're helping with the mediation and be open to their suggestions, be open to what they want to achieve. And so I don't know that answering the question exactly, but that's the closest I can come up with on the spot right now.
Thank you.
Commissioner Rice?
Thank you, sir. We've thrown a lot of questions at you, and we will be throwing a lot of questions at the other two candidates also. What I want to know is there anything that you really wanted us to know about that you haven't had a chance to say?
No, I think if you've read my application, certainly all the black and white experience and on paper, I think that'll kind of tell you my qualifications. I would say this, though. Maybe the best way, hopefully this interview is enlightening for you and helps you in making your decision, but I think the best way is to ask folks that know me, ask folks in the court system that know me. There is a rule under the Nevada judge rules that precludes judges from providing an opinion about me in this situation unless asked. I would encourage you to, a judge, retired judge, present judge, whoever, ask them, see if they'll share. They may not share with you their opinion. Maybe they don't have a good opinion of me, I don't know, but I'm willing to encourage you to give it a shot. Speak to attorneys that are in court. Speak to the court clerks. Who knows better about what goes on day in, day out than the court clerks? Speak to the bailiffs. And I'm willing to bet that you'll hear positive things about me when I say that I'm committed to fair results and treating people fairly and keeping a calm demeanor. I think that would be a good way of verifying that what I'm telling you probably is true.
Okay. And I have several questions, but I also need to do something in full disclosure. First of all, the first 18 years of my life I spent with the last name of Johnson because my mother and stepfather got married a year after I was born, and so I was enrolled in school and went through all my school years as Mark Johnson. It wasn't until I became an adult that I found out that my legal name was Mark Gardner, and so I had two choices: either go back to change my name legally to Mark Johnson, or become Mark Gardner. And based on what some of the escapades of my earlier years, I felt it might be better to just become Mark Gardner. That's a joke, folks. Okay. But it is true that I did spend 18 years as Mark Johnson. Okay. And then of course we have a candidate before us today in Rick Gardner, and I just want to assure the public that we are not. We don't know each other to be related, okay? So that won't bear into my decision at all. So I just want to make sure the public is completely aware of that. With that, I had a question for you. Now, you serve as a justice or judge pro tem since 2006. How often do you serve in that capacity on behalf of the county?
Not a lot, handful of times a year, maybe. Actually sitting in court proceedings and presiding as judge, I would say half a dozen times a year. And then there are other times, maybe there's a motion, some paperwork that needs to be done that Judge Glasson couldn't review because he knows, has too close of a relationship with the parties. Occasionally something like that. Occasionally I'll, have a sheriff's deputy come to me to sign a warrant, things like that. But we could go back and, track the records, I suppose, and figure that out. But if I had to guess, I would say, including, non-presiding in court, 6 or 8 times a year.
Okay, thank you. And I'm going to ask these questions of all the candidates, so it's not particular to you. But can you tell me how you feel the judicial branch in our county fits into our county business? How do you differentiate that?
How it fits into the county business? The administration of the county, you mean? Yeah. Well, it's on a smaller scale, but it's another branch of government, right? It's the judicial branch, not to be confused with, the executive or legislative branch. And I think it needs to maintain that role. Doesn't mean it needs to be at odds necessarily with the other branches of government, but I think you can look at it, look at the federal government as a model for it, and what does the judicial branch do in that context? There are obvious differences, of course, but I think the general theme is the same.
So you do respect, though, the separation of powers in that regard?
Absolutely.
Okay, thank you. I expected that answer, but I just wanted to make sure. I would hope that you've probably taken a look at the resumes and the packages that have been submitted to us by the other candidates for this position. I would expect you to, but maybe you haven't. So I don't want to assume that. But perhaps in that regard, what attributes do you feel that we should consider as a board that would differentiate you from your fellow candidates?
Experience in that court as an attorney more times than I can count, experience in that court as a pro tem judge, experience in related kind of analogous roles as well. I was on the State Bar of Nevada attorney discipline panel. Believe it or not, attorneys break rules at times and they need to be disciplined when that happens. So that has a quasi-judicial element to it. As mediator, as arbitrator. Arbitrator is sort of like sort of like making judicial decisions, but not in a courtroom context. So it's a very similar role as well. I've been a private arbitrator. I've also been selected as an arbitrator through it's called the Nevada Court Annexed Arbitration Program. So I don't know any way other than experience. I mean, I guess there are ways other than experience to prepare yourself for the role. I think that's the best way. To supplement that, I've also, for the last, 5 or 6 years, have been taking classes through the Nevada Supreme Court. The Administrative Office of the Courts has a judicial education program, so I've been taking classes through that. And some of these things are that I might not have learned just being an attorney litigating in that court or even filling in as pro tem. Interesting topics like, Judge Glasson, by the way, has taught a lot of these classes in the past. How to deal with sovereign citizen criminal defendants, things like that. So I think the combination of experience and kind of going out of my way to get more formal education, and I know more is needed, and I don't pretend to have the high level of skill and experience that Judge Glasson has at this point, but I think I can get there.
Thank you. I don't have any further questions, but commissioners, before we allow this candidate to leave, based on the exchanges, is there any additional questions that you might ask? Okay. Okay. Well, as Commissioner Hale says, thank you very much for coming today and making yourself available today for this. And I think the information was extremely useful to us and will help us in our deliberations. And I wish you the best of luck in the process. But thank you for coming forward and offering yourself to fulfill this role on behalf of the county and the citizens of Douglas County. So thank you very much.
Thank you, Mr. Chairman. Commissioners.
Okay. So anyways,